remedies, declaratory judgments. But before we finish with this week's section, and it's not a very long section that we have left, let me make a few points. Trying to make sure that, not for you guys, because you guys are in class, but for those that are listening online, have all of their submissions in, which are due by the end of the semester, the end of the classes. So we really are looking at only about 3 weeks left. And some are behind, and some are badly behind, which places them in jeopardy of failing the course. And others have to make sure they've got all the rest of their submissions in before the semester ends. So there's some fair amount of work to do there for some, but for the most part, let's make sure we complete it so that we can be ready to take the exam, which is really about a month away at this point. So it's a good time to start for those of us that are in class to make sure we start to review and get ready and start to think about. And everyone really should look at some of the older exams, since again, we didn't have an in-class exam. For those of you that haven't had it before, don't really know what the format looks like. So I would suggest that you all look at some of the prior exams so you get a comfort level with what you're likely to see, so that you can express it as well as you have an understanding of it, so that you can do well. So we've only got a few sections left, which means we only have a few weeks left to be able to make sure that we've got everything done that we were supposed to do. I also pulled one of the emails I got from one of the people that's taking it online. There were others of interest in this regard as well about the surrogacy. It's an interesting topic for a lot of people. But I thought this is something that I think we addressed just quickly. We addressed a lot of the terms of those contracts quickly. Oh yeah, I'll take that, I'll take that. I'm not so sure we put as much thought into why we need some of those terms. But, and that would be my fault, not yours, but just to think a little more about how realistic some of the problems are, in that how realistic it is that you'll likely deal with these issues. The student wrote, at the hospital I work at, there was an event a few years ago when a surrogate for hire, her third and last surrogacy, died during childbirth and the baby lived. The surrogate left behind a husband and her own 3 children. And obviously it became a very messy situation when the baby's parents wanted to take the baby home. Surrogate's dead now, and there's an issue as to who has the lawful authority to sign over the rights of that child, since in Mass the rights can't be signed over until after birth. So when we talk about these problems and think about, well, do we get health insurance, do we get life insurance, what do you do if this happens? Obviously this should have been contemplated. But even as we sit here and think about all the things that we could have contemplated, the notion that someone who had successfully given birth to 3 other children, the likelihood is the 4th should be relatively uneventful, turns out not. And now we've got a mess left behind. And that's just one that hit me. I imagine there is some lawyer out there trying to figure out if there is some off-contract claims that either those 3 children or the husband might have at this point. And I doubt it. But that's the first thought that struck me, is who's going to take care of these 3 kids now, and where do you go from there? So I just thought it was an interesting thing, additional thing for you to give a little thought to when you start to think about some of these issues. And obviously there's so many other issues that we didn't even touch on attendant with that you guys are going to practice an area where, in an era where technology far exceeds what we thought was once possible, and somehow you lawyers are going to have to figure out how to create language and statutes and the like to protect people, because that's your job, is to protect people, to try and do something in advance so that we can contemplate, so we can have some measure of fixing what oftentimes is not fixable, not by lawyers at least. So I thought it was an interesting thing to think about, because it just raises another set of issues. But I don't think that's more importantly than why that life insurance policy should be in place. I mean, it sounds like almost a frivolous item, but obviously it's not always a frivolous item, and it's not just a policy to take care of these other kids. Okay, so now what? Now who signs? And I'm not sure you can, not en masse, I'm not sure you can fix that. I'm not sure you can prevent against that. Again, another reason why you want, if you at all possible, the surrogate to be a true surrogacy arrangement, and the sperm and the eggs belong hopefully to the procreative parents, but that's not always possible, not often possible even. So, questions? Anyone want to comment on any of that? I mean, I don't know where you want to go with that. Go ahead.
Could the state, because the state has a law, says the biological or the delivery mom, the surrogate mom, has to sign off. Couldn't the parents that contracted for the baby, couldn't they just adopt at that point instead?
Yeah, but an adoption process isn't overnight. I mean, this is...
that's probably the only solution, right?
Well, I don't know. I don't know. Honestly, I looked at that at 3:30. You know what? I'll bring it home and see what she thinks. Because honestly, I think it's clearly going to rest in the hands of the probate court. And I think that's probably... And I don't know what the answer is. I don't even think there's anything... Maybe there's a statute that covers it. I just don't do enough of this anymore to be familiar with them. But
it's a mess.
Well, it is a mess, and the adoption's going to take months. So I mean, because as it's stated in the email, okay, so now we want to take our baby home. Who can even authorize that if it's not going to be a probate court with some type of emergency order of some sort?
Right.
And so this is what we're going to be fighting about when we've got 3 little kids who just lost their mom, and the likelihood is her partner is beside himself at that point. Jeez, that's putting a lot on someone's plate, but that's the thicket you're going to step in if you potentially involve yourselves in these types of matters. And I think, you know, sometimes you can sit here and say, well, I just won't involve myself in those matters. You'd be surprised what comes through one way or the other. Ends up you're involved in it, in stuff that you at one point would have said, well, I don't really think I'll do that. Well, you know, life has a tendency to get in the way, and people come in with their problems, and these things are not unusual at all. I always get more than a few emails about these arrangements. And someone, by the way, the original developer of the in vitro fertilization process died this week. I think it's in the back of the Globe today. I think it's in the Globe today. I forget what his name was now, but he was the original pioneer of the whole process. Go ahead.
You would expect that before they draft the contract, these risks, would come up. And in the event that she did pass,
They should, but you'd almost think it's likely to be, if you think about it, it's likely to be covered in boilerplate. And if someone really thought that the chance I could die here, they might not do it. And it is a relatively rare occurrence, but as rare as it is, and this is the odd thing. This is the dilemma that we always have as lawyers. We are supposed to the extent we can, guard against the 0.5% chance of a catastrophic event. And in the event we do not, the likelihood is we're charged with malpractice.
Yes.
And on the other side of that is everyone calls us, well, you're the deal breaker, right? And that is what we are, because we are the doom and gloom people. But what if this? What if this? What if that? Oh, listen, and I'll tell you, it's not rhetoric. People say, I don't care. I want to get this done. I'm going to do this one way or the other, Michael, make it work. Geez, I'm not, listen, I can make it work. Listen, I bought when we built our own house like this, I had done a number of construction contracts for clients in building their house, which is generally a pretty risky endeavor. But I had done enough of them that the bottom line is I knew myself is it didn't matter what I wrote in the contract if you don't trust the person that's on the other end of the contract. And so we had a written agreement, but we had more of a handshake as well. And as a lawyer, I knew that's the dumbest thing to do in the world, but if I don't trust him, I shouldn't have been doing this, because builders will promise one thing and end up doing a million other things. It doesn't matter that I had the stuff in the contract or not, because we're tied up for years. And that's the thing, is that oftentimes we're going to have clients more like me. I'm going to take the risk. I want this deal. You figure out how to make sure that my risk is minimized, but I recognize that it's a risky endeavor. And that's the problem with these surrogacy contracts. It's not money. It's not other things. It's so personal that I can tell you there's a million problems with this, and we're going to do it. And now you're still charged with, we'll try to minimize that back end of risk to the extent you can, and obviously without breaking the deal. Because if you really wanted my honest opinion about, and there could be anything, there oftentimes is just too many, the risks of too many significant events happening mean that legally we've got problems all over the place. I can't guard against them all, but what you have to guard against is a client coming back to you later on saying, A, you didn't do enough to protect me, and B, you didn't tell me about any of this. So we got to tell them, even though oftentimes people don't want to hear all the negative things. That's why they see us as deal breakers. But the fact is, if they're not aware of it at the outset, and because you just didn't want to have that uncomfortable conversation, well, that really is likely malpractice. And you see it too often, is where, after the fact, frankly, after the fact, we're going to forget we had a conversation. That's why we often have to document some of the more drastic problems in writing as well. Because I've had a lawyer tell me, if you really didn't want me to do it, you should have stopped me from doing it. I said, I can't stop you. That's not my job, is to stop you, physically restrain you from doing something. My job is to give you advice, to explain to you that this is not likely to work, and it's not just not likely to work, it's likely to work extraordinarily badly. And in fact, I gave you that advice. I gave you all of that. I gave you all of that, and I put it in writing. Well, you should have just stopped me. Come on. At some point, what are we supposed to do? People have free will, and they're going to decide that they don't care. And frankly, I've represented a few lawyers, and more often than not, they know better. And as it turned out, oftentimes they did not. And they recognize that they should have listened, but that's after the fact. And I mean, a situation like this, you could have told them of the risks, but at the end of the day, we still have 3 kids without a mom. And I don't know whether you're on that side of it or you're on the side of the parents who say, okay, that's a terrible thing. The procreated parents, that's a terrible thing that happened to them. We want our baby today. Can we take our baby home today? Right? Because they feel bad. But they still want what they wanted all along. And so I just thought it was an interesting one to give a little bit of thought to, because we thought a lot about a lot of issues. That one we might not have put as much thought into as we should have. And again, it's another thing to make sure. There's a reason why some boilerplate is there in the contract, and that you should probably explain it pretty thoroughly. It's another situation I was thinking about with the boilerplate on you could die or something, and then I saw it this week too. It doesn't make a difference. So did you come up with a definition that would allow you to pass the bar exam with respect to nuisance and trespass? That was your assignment on Tuesday.
What?
Because you...
Right now I'm thinking about freehold, not freehold.
I don't even know what that is. See, when I hit property terms, my eyes glaze over and I go to sleep. Don't you know that already? Well, no, honest to God, what the hell's a nuisance? Go ahead, you got something for us over there?
Everybody has something, right?
It doesn't look it, frankly.
I get person or thing that unreasonably interferes with the health, safety, comfort, morals, or convenience of the community.
Okay, so a person or thing that is an unreasonable interference with the health, safety, convenience of the community.
Comfort, morals, or convenience of the community.
That's nuisance, public nuisance?
Public nuisance.
That's a public nuisance. So a public nuisance has to affect the community as a whole. So what's a private nuisance?
Interferes with a person's...
Wait a minute, interferes, so you're already, it doesn't have to be unreasonable?
I do have an unreasonable...
That's what I would think, Patrick.
Unreasonable interference with the plaintiff's use and enjoyment of his own land.
The unreasonable, what'd you say, interference or use?
Interference.
Unreasonable interference with the use and enjoyment of someone's land.
Right.
Okay.
Or property, any kind of property, right? You would think.
Okay, is it? What do you mean property?
Like chattels.
Is it real estate, or like can you have a nuisance to my tape recorder? So it's real.
That's in real estate.
Nuisance is real. That is correct. Because you're kind of wimpy right now, frankly.
Correct.
Correct. Okay. So it's got to be an unreasonable interference. And listen, the reason I'm sort of a stickler for asking you what the definition is, you can't be expected to get the answer right on either the multiple choice or the essays if you can't, like that, have the definition down, right? I mean, you know, those of you that have had me for evidence, I've asked you what hearsay was, you define it. If I asked you what makes someone an expert, you've got to have your definitions cold to be able to apply it correctly. Otherwise, you're just guessing. So it's not any interference. It's only unreasonable interferences. Is that correct?
That is correct.
So I could, and I'm actually, I don't want to interfere with next week's cases. The woman who used to live next to us down in Plymouth, that we have a cottage down, my brothers and I have a cottage down there. She used to, in the afternoon, she would play her music relatively loud. It was like big band stuff and things like that. Is that an unreasonable interference? The lots are all like small 5,000 square foot lots like you'd find, you know, beachside areas. So 50 by 100 lots. Alice would be next door. And when you came home from the beach in the afternoon, Alice was tipping them back a little bit. And she had the music out in the yard, actually probably sticking in the windows. And you could hear it pretty good. But is that an unreasonable interference? Is that a nuisance?
If it interferes with your use and enjoyment of your home.
What did you say?
If it interferes with the use and enjoyment of your home.
Unreasonable.
Well, wait a minute. Okay, okay. I was going to ask that, boys. Very good. Ash and Patrick say unreasonably. So it does interfere. I couldn't listen to music without hearing her or in the yard. Is that unreasonable? Or, I mean, it's in the middle of the afternoon. Does that make a difference what time it is?
I'd say so. I'd definitely say it depends on that instance.
It depends on what instance.
It depends on, you know, if it's at, you know, 12 in the afternoon, it's a lot different than it's 12 at night.
So Alice can listen to loud music in her yard at 2 or 3 o'clock when she comes home from the beach while she's having her drinks.
Not if you have a baby sleeping.
Well, is that true?
It's a fact. The facts change the reasonabableness, I think.
Does it?
I think it would depend
Middle
on
of the day.
You should close the windows in your bed.
Well, the time of the day I'm telling you is the afternoon. The summertime, so everyone's got their windows open.
Type of music.
type of music.
Does it type of music?
Yes.
Really?
Yes.
So I don't want to hear your music.
You might. You might.
I might like it better than Alice's, frankly. Well, because Alice's, I really didn't care for it, frankly, but it was hers, so, you know, and she was a good neighbor. She was not general, she was a good neighbor. And so, you know, frankly, we put up with it. You know, that's Alice, right? So could that have been an interference? Because sometimes neighbors, and again, we'll talk about the interference with real property rights a lot more next week, but I want you to start to think about this because, again, this is another one of these areas I've had a lot over the years where, you know, one neighbor turns on the other, you know, what is, listen, it's a couple months during the summer, I'm probably there a couple of weeks at that time, I can live with that. if she's doing that all year round, and I come home from a tough day and she's got that damn music blaring out in the yard, at some point this is not going to be funny anymore.
That's when it becomes unreasonable.
What's when it becomes unreasonable? Is when it doesn't stop, or
When you come home and you've had enough.
But so unreasonable means it's subjective, where I wonder, shouldn't that be objective? I'm asking you.
And it is.
And it is an objective standard.
I looked up 3 different, I was looking up something for nuisance anyway, and I got 3 different definitions. So that's why I'm not surprised that everybody says quiet, except for Gary, when there's definitions coming. But one of the definitions I had was whether noise alone constitutes a nuisance depends upon all the attending conditions, including the number of people affected by it and the magnitude of the noise, magnitude that causes the noise. And then it also said something about time of day, just like Kelly said, so yeah.
Well, let me ask you about that. So let me take a step back and try to be even clearer. So noise could let's look at it that way, could constitute a nuisance. Lights?
Absolutely.
Yes.
A dog barking.
Dog barking. We had, back when we initially moved down there was a rooster. No, I'm serious. 5 a.m. 5 a.m. thereabouts, you'd hear the rooster crowing. That wasn't too far away, but tucked into the woods a little bit. It used to be much woodier than it is now. Rooster?
My neighbor.
That actually depends on the town ordinances.
I gotta say this. My neighbor called the cops on her own dog.
On her own dog?
True story.
I have a rooster.
She didn't know it was her dog.
You have a rooster?
I have a rooster.
How do you have a rooster? Of all the people sitting in this room, you would not have been the one I would have picked as the rooster.
Who would have been the rooster?
Well, Derek's thing I know is just north of Boston. I can see Gary having a rooster up in his compound in New Hampshire, just outside the bunker.
Farm animals.
And so wait a minute, though, where do you live?
In Hudson.
Okay, Hudson, New Hampshire. Okay. You have chickens then too?
Yeah, I have hens, and I have about 20 chickens.
Yeah.
And 1 rooster. And the rooster and the rooster crows at 3 a.m. in the morning.
3?
Yep. And
How many acres do you
I
have?
have 5 acres.
5 acres. Okay, so that's it. So, but you can hear that rooster. 3? How come 3 a.m.? I thought it's like sunrise.
So it's whenever really he wants a crow. He crows.
Oh, really?
Daylight savings.
Okay, so.
I'd let my dog out at 3.
And I check that.
Okay, and I imagine he could probably kill your dog though. Got the chickens and the
I got a
rooster.
sneaky dog.
So the rooster could be. Now, Ash says, well, town ordinance, and Hudson says you can have chickens. I imagine a lot of them, we actually have this problem over in Haverhill as well, with the pig farm. We actually have that a lot of different places around here. But over there, what they said is, so, depending on the size of the lot, so many pigs per acre and the like, because of some of these issues. So even sort of natural sounds, like his rooster could be considered. And he said something, by the way, I just want you to think about, again, because we're going to look at this more next week. He said it depends on the town ordinance. Is that true?
Yeah.
So town ordinance says it's okay for his rooster to crow? It's okay because you don't live next door. The damn thing crows from 3 to 5 a.m. every morning. No, and I can hear it. That's not a nuisance? I almost can live with Alice's music. But what about the rooster? And by the way, the rooster across the street in Plymouth, he used to crow, and then nothing else for, he'd crow, so you wake up, then go back to sleep. What if the rooster keeps crowing? That's not, that sounds, even natural sounds could be. Is that true or not?
It becomes unreasonable.
What are you enjoying over there?
That doggone rooster. Oh, I just got to thinking about it. Just whenever he wants to. That's just, man, it's funny.
Okay, but so
Thinking about something different.
so sounds could be. Smells?
Yes.
Yep.
Yes.
Smells definitely.
Yes.
But you're also opening up the other concept of coming to the nuisance, so it's like who was there first might come into that play too.
Well, but remember, we're going to see that we're going to read Boomer versus Atlantic Cement. Even coming to the nuisances doesn't bar necessarily the people from arguing that it is a nuisance and the changing culture of the area and the rest of it. So, smells, sounds, lighting.
Yes.
Anything else?
Objects, yes.
Objects.
Yes.
That's a nuisance or a trespass.
Nuisance.
So if I, right, you've probably heard of these cases, live near the golf course. The balls come into my yard. Is that a nuisance or a trespass? Or both? Could somebody be both?
Trespass. Oh.
Okay, what is it?
So what's a trespass? Golf balls.
Entering onto someone else's land without their permission.
What is it?
I would say
Because that doesn't sound like a full definition.
Trespass.
Trespass is what?
Going onto someone's land
The entry onto someone else's land
without their permission.
without permission.
Right.
That's it? Right? That's it?
Intentionally, yeah. Intentionally.
Okay, intentionally entering onto someone else's land without the permission. That's the definition? Wait
Cause an injury.
a minute, what?
Or to intentionally cause something to.
Creating an affront to the property owner's right to
Okay,
exclude.
but you know what? This is like you're throwing out stuff and just seeing if it hits. So how about
Intentionally going onto someone
intentionally
else's
going onto someone else's
without
property
their permission.
without the permission, creating what?
Or authority.
Creating,
Do I have to create anything?
well, creates an affront to the property owner's right to exclude. So it
Is that
stops-
part of the definition?
Yes. Stops their.
It is? I thought without going on without permission would cover that.
It interferes with their right to exclude.
So does there have to be an interference?
I mean, the intent is not to trespass, the intent is to go where the person
I'm
is
just
going.
looking for a definition that we might be able to use for the final exam if this problem finds its way there.
That's a darn good definition.
What is? I haven't heard. Don't have it.
Intentionally going onto someone else's property without their permission.
Intentionally entering onto someone else's land without their permission. Period.
Close enough.
No, is that it?
Yes.
Okay.
Can we add unlawful
Okay.
unlawful entry?
The unlawful entry onto the land of another without permission.
I don't sure.
Okay, go ahead.
See, I don't know if you
That's
need to
not
be unlawful.
trespass, it has to be, I mean, the intent is not to trespass, it's to go where you're going.
It
So
becomes unlawful afterwards, but it doesn't have
It's
to be
not, doesn't have to be
prior.
unlawful though.
Yeah.
It's going.
Well, let me ask you. Let me ask you about the point. I don't know what the answer is. I'm sure you mavens do. Police officer comes on without my permission, but he has a warrant.
That's not trespass.
It's not unlawful. But
Correct.
if we don't have unlawful in there, then it's a trespass.
No, you gotta put, I have authority in mind. Mine is.
Oh, okay.
Mine is to intentionally enter wrongfully or without permission / authority or consent
Isn't that
on the
unlawful?
real property of another.
Wait a minute. Really? You got too many slashes in there. So
I put a slash in.
well, but it sounds like one of these might work. And he wants to know, doesn't that mean unlawfully then which you're quarreling with?
Rooster.
Huh? So,
Oh, because you can.
okay, give it to us again.
Well, I'll take out the consent part. To intentionally enter wrongfully or without permission or authority upon the real property of another.
Without their permission.
Correct, but you have to put the authority in there to cover the police officer
Except under emergency.
with a warrant.
That's not
No,
what.
that's freaking.
Some amount of-
He's got authority to be on the property. He doesn't have permission, but he's got authority.
Jeannie, what did you have over there?
I have the unlawful entry upon the land of another without permission, causing injury to a person, property, or rights of another, committed with force, violence, actual or implied.
I like that one.
You like that one? You like it, or is that the law? It sounds official. So I could trespass, but if I don't create an injury, it's not a trespass?
That's why you don't
No.
need the extra stuff.
You're still trespassing. Yes.
Wait, what?
Just saying.
You're still trespassing.
Yeah, because you're violating a right.
Okay, so
Right of another.
You can go over to like retrieve something.
Doesn't matter.
do any of you have a Black's Law dictionary, or is that you threw them out after first year?
I used the dictionary. That's what I used.
Huh?
That's what I used.
With my phone downstairs.
I used the dictionary.
We're looking it up. We're looking it up.
Okay, so, but the dictionary didn't have all those slashes there, Gary. That's a Wheaton add-on, I can tell. So,
I put an "ors" to this.
okay, so let's try it again.
I just don't think you need the unlawful part. That's the part
I have an unauthorized
There you go. That's without.
Okay, what? That's without.
rather than unlawful because it's
Okay, so let's hear it.
The intentional entry or causing another to enter another's land without authority, unauthorized. I got it all broken up, so.
I was going to say, it sounds like you just threw that right at the end.
I think we're all saying the same thing. Wrongful invasion, unauthorized
I think
entry.
you're all saying the same thing, but my worries are that you shouldn't, right? You should have a understanding of what constitutes a trespass, shouldn't you? So unauthorized, unlawful entry onto the land of another without permission.
Without consent.
Without consent.
or consent.
Causing damage, then you tell me. Do we need damage?
No.
So if I just intentionally enter, I'm lost.
Yes.
I'm lost. And I sometimes do this. I go walking in the woods behind my house, and then I come up and I go way around, and most of that's public area. Then I say, "Geez, I'm not going all the way back that way," so I just cut through one of my neighbors, the backyards of one of my neighbor's houses. I do it quickly. Is that a trespass?
If you did it quickly because you thought you were trespassing, that's intentional.
Oh, no, it's absolutely intentional. I know it's not mine. I can see the house.
If you did it by mistake, it might not be intentional.
No, because you still intended to put one foot in
Your
front of the
intent is
other.
not to trespass.
That's true.
No, my intent is not to trespass. My intent is just to cut off a couple miles for my return trip.
Trespass.
Yeah, no, I.
So that's a trespass, even though I don't cause them any harm.
Correct.
It's an
You
easement.
still
Don't worry about it.
trespass.
So I still, what?
It's an easement, you're all set.
Actually, one of the houses, there is an easement to the trail, but it's not usually the one I pick.
Unless it's a nuisance to have.
So a trespass, Patrick started to say this, and then we got back to the original. If I take my tape recorder and chuck it onto the neighbor's land, that's a trespass.
Yes. Yep.
So it's not just, it's either me or things that I have, like the golf balls.
Right.
Entering onto that land could be a trespass. Okay. So
the
it's the
case.
intentional entry onto the land of another without permission.
Yes.
And even if it doesn't cause damage, it's a trespass. What if I am lost?
You're still trespassing.
I'm still trespassing. Okay. And you're saying it's we need unauthorized because the police officer's there with the warrant. It's okay, even if you don't want them there because they are authorized. I can live with that. Okay. So the nuisance is not a physical invasion then?
One of the cases I read had an object. This guy owned ocean property, and his neighbor, he had a feud with his neighbor, and his neighbor put up some porta potties in his view where he would be able to see the ocean. So that, the court said, was a nuisance, and it was an object just blocking his view.
On his own land. That's an
On
interesting.
his own land, but to the guy's view of the ocean. So they said that he did it with intent to harass him.
I'd be interested in seeing that case, but that is the situation, though, right? Is I can do something on my own land that nonetheless causes a nuisance on your land, if it's an unreasonable and intentional interference with your use and enjoyment of that property. And the difference in the public is that it affects a broader area, right?
Because that's the case in property where I think where the guy was shooting ducks or something. Scaring the ducks away from his duck farm or something.
Decoy pond.
Or something. And so he was doing it on his property, scaring the guy's pet ducks away or something.
Okay, so this case that we were looking at is the bookstore case, the pornographic bookstore. Could that constitute a nuisance? No. Why do you say? Are you kidding when you say no?
I'm joking around.
Okay, so could it?
It depends on the neighborhood.
But what do you mean it depends on the neighborhood?
Does it threaten the health, morals, public
Well, what,
welfare?
well, oh, by the way, that's right. You guys had health, morals, public. You guys had a lot more in there, right?
I had morals in mind, yeah.
So
Because I knew the case was
we're not surprised. And that is what the case says, right?
Yeah. There's lots of kids in the neighborhood.
Interfere with the health, safety, peace, comfort, or convenience of the community. And I don't know, did this actually say morals in this case, or did you just add it based on this
No, I
case?
got it from my dictionary.
Okay. And what,
That's my story.
is that the Scalia version, or is that a version that we all can trust?
It actually was. It wasn't blacks. It was one of those little ones.
Okay, but we could find cases. Well, let me ask you. This is the case. They bring it. The prosecuting attorney brought a proceeding to close down the bookstore as a public nuisance. Could just a bad bar be a public nuisance? Sure. Forget the pornography that's present in this. Could a bad bar,
Yeah.
fights,
Poorly managed.
That could constitute a public nuisance.
They have a motorcycle bar in Hampton, and they also got a rooming house in Portsmouth, New Hampshire. That's just a rooming house, and all the neighbors want that gone.
Well, I could show you. There's a rooming house in Lawrence. Actually, one of them has been closed as a public nuisance.
That's Lawrence. Andover might be a problem.
Well, I think it's a problem, and I think the neighbors thought it was a problem in Lawrence. I remember when there were times where they're across from a park, common, and kids play in those parks, and there's lots of needles, discarded needles, and everything else in those parks. And part of it is obviously attributed to the occupants of the rooming house. I mean, could something on your own land constitute a nuisance next door, or again, public nuisance would be even further away? Because I also wonder, and again, some of this is for next week, is even if it's authorized by the statute, it could still be a nuisance. Like, okay, you're supposed to be able to sell beer at 2 o'clock. Closing time is 2. But from 1 to 2, that bar gets so rowdy, spills out into the street, we can't sleep, whatever it is.
I think for it to be that way, it has to be continuous.
What do you mean? Contiguous or continuous?
Continuous, every single night or whatever.
Every single night, or Friday and Saturday night's enough for you?
If every Friday and Saturday this is happening.
Well, let me ask you if you start to think about it though. So okay, I live next to that bar. Most bars, Friday, Saturday night, come 2 a.m., they're going to empty out. They're going to be noisy and loud. Could I actually get one of you to file suit against them to try and close them down, or at the minimum to get me some money for this aggravation? Because my guess is there would be a lot of people living next door to commercial establishments like this that might like to take their shot. We even have it's not my town, Boxford, which is the next town, there's a lawyer who lives on a main street. He lives next to a farm, Inglesby Farm, and for years they have been fighting about the farm being a nuisance because they sell coffee in the morning and pastries and things like that. People come, they then have the pumpkin patch rides and all the rest of it, and his argument is that this is commercial, this is not farm anymore, and that's interfering with the use and enjoyment of my property. Even though some of us might think it's a nice use, if it interferes with your use and enjoyment, that could be a nuisance. So what about the bookstore? Help me out with this bookstore. If you live next door to this bookstore, is it a nuisance? And here we say public nuisance, and somehow the public has to be it has to interfere with the right common to the public, right? So could the clientele to the bookstore and any other attendant uses of the property, could that be an unreasonable interference? Would you want to live next to it?
When I was younger, it was okay, but after I had kids, you know.
Okay. I'm not so sure how much younger you need to be to want to live next to it at any rate. But is that an unreasonable interference? Because it's an objective standard too, right? Because otherwise, whoever lives there gets to make these decisions that affect someone else's livelihood. Because what we've got here is this, again, this question about, well, he says it's a civil right. If you're going to do this, you're violating his civil rights. He's brought a 1983 action for violation of his civil rights in federal court. And what he's saying is that my civil rights are being affected as a result of what the DA is trying to do here. Federal court, you should allow me to proceed with this action and potentially issue an injunction against them proceeding in this way, which again brings us in almost direct, well, pretty much in direct conflict with this whole notion of states being allowed to regulate activity within its borders and the federal government being allowed to regulate activity within its, and neither should be interfering with the proceedings in the other. Because that's precisely what he's trying to do here, isn't he? He's trying to get the federal court to step in to this pending state court action, because the prosecuting attorney has already brought a proceeding to close down the bookstore as a public nuisance. The state court entered a preliminary order prohibiting continued operation of the bookstore. So he's out of business if the federal court doesn't help him out here. But the federal court, as we know, has a problem from the Anti-Injunction Act, which says you shouldn't involve the federal courts in pending state court matters. Maybe it's a nuisance under Florida law. Certainly, it doesn't take a lot to argue that it is an unreasonable interference, what would take place there and how it would operate in all likelihood. I mean, I certainly wouldn't want my kids to be playing in the yard next door to this. And I do think it would potentially interfere with that use. And again, we're going to see next week when we look at this, there's a million different things that people fight about when you think about nuisance and trespass. Whether it's lights from next door, whether it's Alice's music. In our town, we have both a waste treatment facility, which at times gives off, if you live near it, the odors are horrific. We also have a trash facility that burns, so you get smoke. Even and near us, really near us, it doesn't bother me, but I could see some would argue, we have a coffee roasting facility, and I think it smells great, but I could see where others, and I've even had someone here tell me that the microwave popcorn is seriously, is that it's offensive, the smell of it. Not even just burning it, that somehow that whatever is in it triggers some type of reaction for them. And so therefore, is it there now? Because for a while it had to be removed from the machines. What someone likes, other people don't, and it's not just like potentially. This was a reaction, health reaction. At least that's the way it was carried out. That you had to say it's like, oh, I wouldn't give you all peanuts if I thought you had peanut allergies.
I think one of the courts argued that it can't be an overly sensitive person, but the opinion of many. It can't be just because the popcorn bothers just one person.
So you took it out for one student? I'm sorry.
Speak up, come on.
Well, what do you want to get out of the machine, Stevie? It was presented as akin to a peanut allergy, that the person would have reactions to the smell of the popcorn cooking in the microwave that would adversely affect her health. So you had documentation to support it. So you can't risk someone's health. So what do you want, all those banana chips and stuff gone from those machines? Replace them with Twinkies? Okay. The case is here because, again, we've got this conflict between federal courts and state courts. In invoking his 1983 action, Are civil rights actions an exception to this notion that federal courts have to stay out of pending state court matters, as the plaintiff, the owner of the bookstore, would like to have the court do? At the end of the day, the court says you can treat requests under 1983 for violation of civil rights differently, because they are designed specifically to protect against unconstitutional actions that operate under the color of state law. And so therefore, I don't know whether the court will issue the injunction, but it does in fact have the power to grant the injunction should it against the pending state court actions if it believes that his civil rights are being violated by someone acting under the color of state law. And so this is really sort of the exception to the rule, and I guess if you wanted to do this, then you've got to plead 1983 civil rights actions. You've got one more case here, and it's the Francis versus Horowitz case, and it's here again for a declaratory judgment. It's from Massachusetts. And it's here for two different reasons. I wanted you to actually see what those findings of fact that we've talked about on a bunch of different occasions actually look like as the case. This is, in fact, a reported decision, but the case simply really, if you look at it, lays out what the judge's findings of facts are in arriving at the decision. And then the last half of it shows you what those conclusions of law look like. And so we've got 69 different findings of fact. And then what we've got are the conclusions of law, which simply are what the judge says the law is as applied to these facts. I found this an interesting case because this is in downtown Boston. We have a lot of these types of situations in Boston and elsewhere in cities as well. You start to think about trespass and nuisance and all the rest of it. You'd never walk through the North End again without looking at some of the overhangs and say, Jesus, that looks like that's probably in someone else's property. You look at the methods of egress and access to some of these units, and they clearly are with respect to, I think this was the fire escape, right? That whether it's by easement at this point or otherwise, they have to exist there, because otherwise you may not have lawful access to the premises, which makes the property unusable. And so I thought this case is an interesting example of both the findings of fact and conclusions of law that you would be filing at some point. But it also lays out, I think, a good case for declaratory judgment, where what they need is an order that would explain what's supposed to happen with respect to what took place here. And the property shared an adjoining wall, but one without permission just simply decided that he was going to take matters into his own hands and change what had been the ability to access that property and the like. And obviously they have at this point a right to go in and seek a declaration of their rights with respect to what needs to be done, and then also request the court to have injunctive relief issued that would order them to restore what it is they took from the plaintiffs. And if you look at the conclusions of law, it says to prove trespass to property, plaintiffs must show legal possession of property and an intentional interference with the property without license or justification. So that's where you were talking to me about whether it was unlawfully or without permission, or what was your other language you added? Unauthorized? Right. So here they say without license, which would be permission, or justification, which would probably be the warrant situation. So plaintiffs must show, and that, right, if that's the other part of it, is obviously they have to be in possession of the property to claim trespass to their property, or someone else has the potential claim. And then they talk a little bit about prescriptive easements that you should be aware of. We talk about adverse possession that I'm sure you've studied in property. But at the end of the day, what the case is here for is they want a declaratory relief to restore that second means of egress, as the court feels it is in fact appropriate, because they removed it. They removed it intentionally, and they did it in order to benefit themselves at the expense of the plaintiff. If you look at the end of the decision, order for judgment, so we've got the findings of fact, the conclusions of law lay out what the law is, and the court has addressed their various claims, including the 93A claims. And then there's a judgment that's attached at the end of the decision as well. And so some of the counts they succeed on, counts 1, 4, and 6 of the amended complaint, and they get the declaration that egress has to be restored to the property. They get an order for number 2 for their costs and attorney's fees. Plaintiffs have to submit that, and that's often the way that works as well, is after the case has been resolved, there is a second hearing of some sort on what the award of attorney's fees would be. Some of the claims end up being dismissed, and then what happens here is that the court has to wait and hold the case until such time as they determine what the extent of the attorney's fees awarded in the case are. So I think it's an interesting use of declaratory judgment attached to other causes of action, including 93A, which you've studied before, talks a little bit about negligence, it talks about injunctions, and I think this is the type of thing that you have to start to think about more often is, you know, especially for remedies, you're not going to have potentially a single issue problem for the final. You're going to have to think about 93A and injunctive relief, damages. You're going to have to think about contracts, and if it's a contract claim, or if there's a negligence counts, or if it's trespass and nuisance that I should be thinking about adding as well. And to use those collectively to try and figure out what the rights of the parties are as to how you would resolve this. And so I like this because it showed you, I think, what those findings actually are supposed to look like, but it also went through the various different theories, legal theories that are advanced with an effort to try and show you, hopefully, point out some of the difference between what a trespass is, as well as how the declaratory judgments, declaratory relief can be joined with other causes of action. Questions on the case? This is an area, by the way, back when the case was filed, it was, well, still old, still a dozen years ago. It was a horrible area. I went by it recently, and it's, Suffolk is down there, Suffolk's undergrad is down there for dorms now, and Emerson has a lot of renovation in the area. It's an area that has made significant improvements from what it was like through the 80s and 90s and early 2000s.
Combat zone.
Used to be called the combat zone, and much of those activities now, I don't know where they went, but
Between Chinatown and the old combat zone.
there's not much left there. Questions on the case? Huh?
Combat zone.
That's what it was called.
Wait a minute.
No. It was dangerous, and it was seedy.
Like Times Square.
Oh, you got a rooster?
Times Square.
3 a.m. I wouldn't want to see him, though, Ash, I'll tell you that. He's a good-looking rooster, though.
Handsome, isn't it?
He is handsome. Want to see his rooster?
Kelly wants to see.
He's good-looking.